So welcome back to land transactions. Iron sharpen iron, and there is this quote by Albert Einstein that I like so much, that if I have 6 hours to cut a tree, I would spend the first 4 hours sharpening an axe. And that's exactly what we are doing today. Let us sharpen our axes, that by next week we are really good to go. So if you listen this video up to the end, I will share with you one of the lessons that helped me pass an oral exam as far as land law or land transactions is concerned. So please, I promise you that you are going to get value for your time, because time is more important than money. So if you are going to spend the rest of 40 minutes watching this video, I promise you that you're going to get a lot of value from this video, because I understand that as an LDC student, you really do not have a lot of time. But also, I appreciate that motivation is not important as discipline. So I need to motivate you, but also I need to make sure that you are more disciplined. So let me share with you the substance, and I hope that you are going to fill in the detail when you meet in your farm discussion. So this is land transactions workshop, and basically we shall be tackling interest in land. The model deals with rights in land, how they are acquired, protected, controlled, regulated, and in some cases how they may be lost. So we shall look at rights in land, and basically we all agree that a right in land can be legal, or it can be equitable. And how are they acquired? Of course, a right in land can be acquired by purchase, and also we're going to look at other ways of acquiring a right in land, and then how it can be protected. We're going to look at caveats and controlled, and in some cases how they may be lost. So they may be lost, which are going to look at circumstances like adverse possession. So the learning outcomes. By the end of this workshop, you should be able to, one, explain the difference interest in land in Uganda. So basically here we talked about legal interests, and we see that a legal interest is the one which is registered. For example, if you have a certificate of title, you have a legal interest. Then we also talked about equitable interest. Equitable interest include these ones which have not been registered. For example, if you have a sales agreement, I know most of you people have bought land and you only have sales agreements. So that now is an equitable interest. So when you proceed to get a certificate of title, then now that becomes a legal interest. So illustrate the principles relating to acquisition of interests in land. So basically, I want to look at these principles that basically govern how do you acquire an interest in land. And also we shall be guided by section 54, which say that all these interests must be registered under the RTA. Then structure transactions relating to acquisition and protection of interest in land. So basically here we're going to look at a sales agreement and how to draft one. Then we shall also look at draft various documents for acquisition and protection of interests in land. So the various documents that can help you to acquire land, to acquire interest in land, one include a sales agreement. We shall look at the trust deed. We shall also look at a vesting order, among others. So recognize and deal with ESCO issues relating to acquisition and protection of interests in land. So among the ESCO issues we are going to look at, one is not overcharging client, then also the duty of the registrar to do according to what the law tells him, and also making sure that you carry out proper due diligence. So preparation for the workshop, you're expected to read the following. One, Constitution of Uganda, basically Article 26, Sub-Article 1 and Sub-Article 2. So basically Article 26 speaks to the right to ownership of property in Uganda, and basically Article 26 Sub-Article 2 speaks to how the government can acquire land compulsorily for purposes of public interest. So when you look at this, basically the locus classicus case is the case of Asman Ilumba versus Anthony General, and I'm sure that we are all aware that that case challenged the sections of the Land Acquisition Act, basically which gave the government right that you can acquire land, when you have not done prior and adequate compensation. So the court was very diligent and stated that no, this was contravening Article 26 of the 1995 Constitution. So for government to acquire land for public interest, it must adhere to the canons of Article 26, which basically speaks to prior, adequate, and enough compensation. So basically they're also going to look at Article 23-237, which basically gives you the different tenure systems that one can hold land in Uganda, to include leasehold, freehold, customary, and also milo system. But also much important is Article 237, sub-Article 1, which states that all land in Uganda shall be owned by citizens and vested in the government with the trust of the people. So we are going to look at the RTA, and basically here in the RTA we shall be interested in section 46, which should be read together with section 48, and these ones speak to effective date of registration and priority in registration. So basically, if you have read the case of Nigeria versus Kizito, it speaks to different competing interests and how the date of registration will be given priority. So this can be read from this section 46 and 48 of the RTA, that if you have two competing interests in land, the first in time in registration takes precedent. Then the other section I want to look at in the RTA, basically section 54, which talks that every instrument that transfers an interest in land must be registered. So these instruments include a trust deed, they include the sales agreement, they include a mortgage, they include the powers of attorney. So all these instruments which transfer an interest in land must be registered. So I don't tell you those instruments because I know them, but because that can be an oral question. So I want you to understand that an oral question can come asking you to list any 5 instruments that can transfer interest in land, and by just mentioning those ones you will have gotten your marks. Then also looking at the Land Act and basically section 2, which also talks about the different land tenure systems in Uganda, but also section 3, which gives the features of these different land tenure systems. But also most importantly is section 29, subsection 1 and 2, which speaks to lawful and bona fide occupant. And if you have read the case of Judge Tirirwe versus Caroline Gwamhanda, they basically explain or define what those terms mean. A lawful occupant is a person who has entered land with the consent of the registered proprietor. So when we look at subsection 2, which basically speaks to a lawful the bona fide occupant, because I've said that a lawful occupant is the person who enters land and settles on it with the consent of the registered proprietor. And the decision for that is the case of Hirirwe versus Caroline Gwamhanda. So when you come to section 39, subsection 2 of the Land Act, they speak to what we call a bona fide occupant. And they said a bona fide occupant is any person who has been settled to the land by the government or any agent of the government, for example, a local government authority. So you have to really identify and look at those sections, because they're going to be very important for our discussions next week, but also for our IA, but also for our oral exam. Then we're going to also look at the Physical Planning Act. Basically, the Physical Planning Act declared all areas in Uganda as physical planning areas. So that means if you want to construct any building in Uganda, you must seek permission from the district land committee, which basically gives you permission. That is under the Physical Planning Act of 2010. Then also we are going to be guided by the Citizens and Immigration Control Act, and basically we know that it's only citizens in Uganda who can own land, but only non-citizens can own land in Uganda when they are through leasehold. And the decision for that, you can see the case of Bayizika Enterprises versus Bayizika Farmers Limited, but also the decision in Sidire Praria and Mera Investments Limited versus Queen Bank in receivership. So I think basically those are the key statutes I can point out. Now let me proceed to cases and other authorities. So we are looking at now at interest in land, and we have defined that an interest in land is any right that gives you liabilities in land, either to enjoy a profit or a loss. That's how I can define an interest according to Osborne's Concise Law Dictionary. And there is this case of Boise versus Gasure. In Boise versus Gasure, what happened is that the person lodged a caveat on land, but then that person did not indicate his right in that land. So the court was very clear and straightforward, and said that for you to lodge a caveat in land, you must show under what interest are you lodging that caveat? So sale of legal and equitable interest in land. So we clearly distinguish between a legal and an equitable interest, and we say that a legal interest is the one which is registered, whereas an equitable interest is the one which is not registered. And we have the decision for that, Katarikawe versus Katwiremu. They really explain what amounts to an equitable interest and also a legal interest. So for example, if you have bought land and signed a sales agreement, you at that point have an equitable interest. But if you proceed to register that sales agreement and also you get a certificate of title, then now your interest is legal. So need for due diligence in land transactions. So I'm very much aware and also I'm very passionate about the decision in Uganda Posts and Telecom versus AKM Rutaya, because the Court of Appeal was very clear, and the court stated that land is not like vegetables where you buy from unknown vendors. And I hope that decision interests you, and also you find it interesting that land is not like vegetables that you can buy from unknown lenders. So also that was set in the case of Sir John Bageire versus Aus Matovu, the Court of Appeal decision. You have to read that case, but basically that would be a very good decision to put forward before the panel in case they asked you why is it important for you to do due diligence. Those are some of the things that make sure they persuade the panelists and they understand that now we have a bright student before us, and when you have appeased them, of course I want to appreciate you by the marks. But also when we look at the due diligence, you must also appreciate this decision in David Sejaka Nakalima versus Rebecca Musoke, where the council had proceeded to buy land, but he saw an old woman on the land, but he did not ask how he came about to the land. So the court later stated that by the fact that your lawyer had seen this old woman on the land and did not proceed to carry out any due diligence as to how she came there, then fraud could be imputed on you. So it basically means that courts have said that if you fail to do the proper due diligence, then court can impute fraud on you. And I'm very sure that you also know the impute of fraud on a certificate of title, that a certificate of title can only be impeached in instances of what? Of fraud. That is of course pursuant to section 59 of the RTA. So you have to basically do proper due diligence because of that decision, because if you have not done proper due diligence, even if you have gone or proceeded to get the certificate of title, the court can still impeach it on the ground that you did not carry out proper due diligence, and also the decision in David Sejaka Nalima versus Rebecca Musoke. Then from there we see that the importance of certificate of title, and I have talked about section 59 says that the certificate of title is conclusive evidence of ownership, and you must be guided by the decision in Kampala Butcherers versus Damionico. Then from there we see tenants by occupancy on land, and we talked these are covered in section 39 of the Land Act, and basically we looked at the decision. They are covered in section 29 of the Land Act, where we have lawful occupants and bona fide occupants. And the locus classics case is George Tumuhirigwe versus Caroline Rwamhanda. Then from there we look at family land, and I'm sure we have looked at the decision in As Accor versus Global Capital Bank, and also the decision in Mwebazi versus Birigwe Stephen, where the court have said that you cannot deal with family land when you don't have spousal consent. And basically family land was defined to mean the land where the family or home derives its sustenance. So you must be very clever and polite to distinguish between the difference between family land and also matrimonial property. Whereas matrimonial property is where the family or the husband and the wife stay. A family land is where the family derives its sustenance. So we look at consents to deal with. So you must get consents, for example, if you're dealing with family land, so spousal consent, but also in some instances you can get, if you're dealing with land of under the estate, you have to get consent from the beneficiaries. Then adverse possession. So adverse possession, basically how I can explain it is if you have stayed in land for 12 years and you have not been challenged by any person, then you can proceed under the doctrine of adverse possession to apply for certificate of title. So I hope you have understood that. But to understand it more, you can read the case of George Kasande Mukasa versus Emmanuel Wabenda, where the court stated that for you to proceed under adverse possession, one, you must proceed that you are in the occupation of that land, you have stayed on that land for 12 years, and you have never been challenged by any registered proprietor. So I hope that was a very good introduction. Of course, I'm very passionate, but I'm also excited, and I really want you to pass, because land law is one of the course units or category A subjects that gives headache to bus students. So that's why I'm very passionate and considerate in the way I'm explaining it. I hope that next week becomes one of your best weeks at LDC, because land law is very easy when you understand it. So we're going to workshop 1. So the workshop deals with identification of different rights in land and the requisite steps or inquiries one undertakes to establish the viability of a peaceful land transaction, learning outcomes. So by the end of this workshop, you should be able to, 1, explain the different interests in land in Uganda. We have explained that, legal and equitable. I don't need to go back. Illustrate the required due diligence and undertake to establish a viable land transaction. I have talked about that. You have to do a physical search. You have to do a search on the title. You have to do particulars. All those searches, of course, being guided by the case of Vangine, but also the case of Sejaka Nalima. Then we also draft various documents one needs when establishing the viability of a possible land transaction. Of course, you need one. You can need a consent form if you're dealing with a spousal land. You can draw a sales agreement, and you need the transfer forms. So for recognize and deal with ESCO issues relating to so ESCO issues, we have been really, so it shouldn't be a headache at this point. ESCO issues, you are dealing with the offices involved. For example, here lawyers shouldn't overcharge. They should also advise their clients to do proper due diligence, and also the registrars shouldn't take bribes. So facts: you are a legal officer working at PNA Advocates located at Plot 47 Kampala Road. The senior partner, Mr. Smith Ayewa, informs you that Ms. Patience Ahumuza, a long-term client, has a real estate business in Uganda known as Smart Developers Limited. Mr. Smith then tells you that she and her family relocated to the United States of America. However, Patience informed him that ever since she left Uganda, managing the business has been difficult, but she knows that during the third quarter of the year, Uganda do purchase land so as to start the new year with newly acquired property. He then tells you that Patience wants to quickly sell off all her properties in Uganda. The particulars of the properties Patience wants to sell off are as follows: land comprised in Wakiso Block 321, Plot 162, Busuku, measuring 3 acres. This involves the residential house in which Patience resides with her husband and other family members. Land comprised in FR V984027 Plot 11 Chizoba, measuring 85 hectares. Their own is a farm with cattle, goats, and sheep. Part of the land, measuring about 165 acres, is used by Patience's family, and his a large banana plantation used for both sale to marketers and for subsistence, from which Patience's husband collects fruits and vegetables for the family every weekend. The rest of the land is exhaustively occupied by Mzee Matama, aged 70, who claims to have inherited the same from his father 40 years ago, and has his own banana plantations on it. Part 3, land comprised in RL41289415 Plot 437 Kasanga, Kampala, on which there is a large 4-storied commercial building fully occupied by tenants. Roman numeral 4, land comprised in Nakaseke Block 43, Plot 212, Bruins, registered in the names of Patience children aged 6, 5, and 3 years respectively. The land has rented lock-up shops that were purposed for the well-being of the children. Currently, Patience is collecting rent from the said premises. Tasks. The partner at the law firm has asked you to advise the client on the following: A, the pertinent aspects about the land in as it discerned from the facts and the certificates of titles presented to you. So you have been given a copy of certificates of certificates, let me hope that you opened them and you read them. Not because you want to pass this workshop, but because in an oral exam you can be given a certificate of title and you will be asked questions. But let me first give you an overview of what you should look at when you're looking at those certificate of title. So when you look at part 1 of the certificate of title, it has the description of property. So basically here, the description of property will have to understand where the land is located and whether it's mile or freehold or leasehold and its hectares. So when you want to know details of those ones, of the description of property, you go to part 1. So part 1 is always after the first page. The first page is big and titled the certificate of title. So when you leave that page, you go to part 1 where you have the description of property. So from there you go to part 2, which has ownership. So basically in most of the certificate of titles, you'll find that there are a lot of names which are closed. So that basically means that the certificate of title has been exchanging hands. So if you are the owner of the title today and you said to me the next date, so your name would be cancelled and then the title will have my name uncancelled. So if I also served another person, so my name will be cancelled just like that. So if you want to know the owners of the title, you just got ownership, because sometimes you will find that the ownership are either joint tenants. We have 2 people, that means they're joint tenants, or you can find that the land is owned by the company. And when you find that the land is owned by the company, that means that there are different rules that applies to that land. Then after that, you go to the deed plan. The deed plan is always read by surveyors and helps in opening boundaries. So where there is a conflict in the boundaries of the land, so the surveyors will come and read the deed plan and will help them to open the boundaries. Then after that, we have the conditions page. So the conditions page is always, for example, in leases, but also some other titles have the conditions page. So for example, you find here that they are saying that this land is strictly for farming. So that means you cannot buy land and build a house, because the conditions page gives you farming as the condition. Then we also have the encumbrance page. So the encumbrance page basically has all other rights of third parties. For example, it could be a mortgage, it could be a caveat. So all those ones, you look for them on the encumbrance page. So after having understood how the certificate of title is structured, then you should go back and look at your certificate of titles and see whether you can identify these things. Not because you want to pass the workshop, but because it can also be your oral question. Then after that, we are first with workshop block 321, the first title, which is in Busaku. So that one, it has a matrimonial home, but also there are joint tenants. So when we say joint tenants, that means first and foremost, that means you have to apply the law of matrimonial home. You have to first get spousal consent from that property. Then also joint tenants. You know, you cannot deal with joint tenants by dealing with only one person. You have to deal with both of them. You understand? Then if it's the title is owned by, for example, when you look at the title 2, which is in Chizoba 98, there is family land. And also look at family land, you must have got spousal consent, because where the family derives its sustenance. Then we have this Mzee Matama. So Mzee Matama is who? Mzee Matama is who? Is first and foremost is a lawful occupant. So he's a lawful occupant because he has been there for more than 12 years. So that means he's a bona fide occupant. So you have to distinguish between a bona fide occupant and a lawful occupant. And we say the bona fide occupant, according to the case of George Tuhiriri versus County Wamhanda, is that a lawful occupant settles on the land with the consent of the registered proprietor, whereas a bona fide occupant settles on the land with the consent for when has been there for more than 12 years, or he was settled on that land by the government. Then we have Title 3, which is 1289 plot 437 in Kansanga, and this one is owned by Smart Investments Limited, and they pay ground rent of 1.5. So here what you have to understand is you have to put these tenants on notice if you're going to buy this property. They must be aware. But also there is an encumbrance, a mortgage. So if you are going to buy this land, remember you're going to buy it subject to that mortgage. You're going to buy it subject to that mortgage. But also, since this is a land owned by the company, then you cannot buy it without a board resolution. So we are going to need a board resolution to buy that land, like how we saw in company law, that the company speaks through its resolutions, either a board resolution or a special resolution. But in this instance, we need a board resolution. Then we're also looking at Nakaseke Block 43, Plot 212, the land which is owned by the miners. And we know that in miners, when the land is owned by miners, the only way we can deal with it is by getting a guardianship order. And in getting this guardianship order, when you go back to family law, you know that in all matters to do with land, you must proceed under the children's best interest principle. And the children's best interest principle basically states that in every dealing where the child is involved, you must prove that that transaction is to the interest of the children. So basically that's what we are trying to explain here. So having said that, then part 1A has been answered in its entirety. So we go to part 2. All the required steps and inquiries you would undertake when carrying out due diligence, and have been guided by the decision of where we say that land is not vegetables, whereby you can buy it from unknown vendors. So that basically means that you have to do a physical search, you have to do a search from the registry, and you have to also identify the particulars of this person, whether they match on the ones on their national IDs. So there is a clear step of how to do a due diligence. But you must also be notified by the decision in David Sejak Nalima versus Labeka Musoke, which basically means that if you don't do proper due diligence, then fraud can be impeached on you. And if fraud is successfully imputed on you, that means your certificate of title can be impeached. So the rights of any identified third parties and other legal factors that substantially affect any intended transaction. So we looked at this Mzee Matama, who is basically a bona fide occupant. So you cannot just evict him, you must compensate him. We also looked at joint tenants. And if the land is owned by joint tenants, you cannot deal with only one person. You must deal with both of them. We also have a land owned by a company. You cannot proceed with it without a board resolution. And we also have a land which is under mortgages. So basically means you have to buy it subject to that mortgage. Then you also have a land which is owned by minors, and therefore you cannot deal with that land without a guardianship order. And we said there you have to prove the child best interest principle. So draft any documents you use at this stage. So basically the documents here, we have the spousal consent, we have board resolution, we have also something seeking for guardianship order. So those are the documents which can be applicable at this stage. So having said that, I'm done with workshop 1. But allow me to put this advert that we have a mastermind group. This mastermind group is composed of very, very bright students, and they are very determined from Barara, from Lila, and from Kampala. So we always have discussions on Saturday, which are done on Google Meet from 4 up to 6 p.m. So we get to look into workshop 1. So we go into details and we reconcile all the positions that comes from different farm rooms. And after that, by 8 p.m. the close of that date, we give a document which has all the notes that can help you to copy your notes. Then on Sunday, for us, we don't rest in the weekend, because I've told you that discipline is more important than motivation. On Sunday, we go back to workshop 2 from 4 up to 6 p.m. So we also we reconcile all the different positions that come from different farm rooms, and then we come to agree to one position, and before next day by midday, the notes are out to help you begin is the notes. Then you can also appoint physical appointments with me during the week for 2 hours, so as we can go in detail. So that's our part of the mastermind group, but it's a small subscription. So please, if you are interested, you can inbox me, and I will be happy that you join us and we pass or we simplify the complicated. So having said that, but also if you don't understand, I can understand that. That's why I do this YouTube video with all the passion that I can help to guide you, and also you go and fill in the details. So when you go to workshop 2, the workshop deals with how the rights in land are acquired, protected, controlled, registered in some cases, and how they may be lost. I explain that. So by the end of this workshop, you should be able to 1. Explain principles relating to the acquisition of interest in land, or we did that. Structure transaction relating to acquisition and protection of interest in land. Draft various documents for acquisition and protection of interest in land. Then recognize and deal with issues relating to acquisition in land. So you should read the following registrations. I can't go back to this. Let us go to cases, power of attorney. So we all know power of attorney is the document you sign. The document you sign whereby you're giving your powers be done by the other person. So the power of attorney is governed by sections 130 of the RTA. So when you look at section 130, this document must be attested to. And basically, when you read the case of Frederick Zimbabwe versus Orient Bank, they have said that 1, the scope of the powers must be very well stipulated, but also it must be well signed in Latin character, but also attested to. And also you must proceed to register this document under section 54 of the RTA. Then rights of parties, the transaction of the sale of lands. So we have this decision in Haj Abdul Nasser Katende versus Ronald Hadalas, whereby they discuss all the rights of parties in a transaction. Basically, what is a right of a vendor and a purchaser? So if you today went into a transaction and I bought your land and I paid you 100 million, and then after that I failed to pay the remaining balance, and you get a mzungu, and this mzungu is giving you 1 billion from the same land, can you proceed and sell it, or you cannot? So what are the rights of the purchaser and the seller at that point? But I will answer that question when we go to the workshop. Please stay with us as we go to workshop 2, because that's a very, very, very important question, and it can be part of an oral exam. So essence of time, of course, time is very important. Like the way we saw that priority of title goes with the date of registration. Then powers of an executor or administrator of an estate. So basically, the power of an executor, if you look in this case of Blaise versus Caesar, is that you are supposed to pass the interest to the beneficiaries. That's the power of an executor or administrator of an estate. Then rights of the beneficiaries. So these rights have been tackled in the first case, Israel Kabga versus Mountain Banabo, but also a beneficiary. One, we have rights now. A beneficiary can sue, has the right to sue on behalf of the estate. You can also lodge a caveat. All those rights are available to a beneficiary, and that's why we come here now on a beneficiary's caveat. And I think these ones are provided for in section 123 to 129 of the RTA, if you want to appreciate the law governing caveats. But also you have to understand that a caveat can be lodged by any person who has an interest in land. So vesting orders. So we looked at vesting orders. We also looked at adverse position. So a vesting order, if you read the case of Rwanga versus Registrar of Titles, or the decision in Re Ivan Mutaka, you must prove these things. 1, that you paid the purchase price of the land. 2, that you are in possession of the land. 3, that the vendor or the seller cannot be found. So if you have proved all those conditions, you can proceed under section 78, and you apply for what we call a vesting order, which will be supported by a statutory declaration to have that land vested in you. Let me hope you have understood this, because this can be an oral question. So basically, let me go back and explain to you what's the difference between adverse possession and a vesting order. And I'm saying that adverse possession is where you have stayed in land for more than 12 years and no and the registered proprietor has not challenged you, so you can proceed to apply for a title on the doctrine of adverse possession. Yes, I know you have got that. Then let us go now with what? To vesting order. So where you have bought land and the person cannot be found, maybe he died or he went abroad, but you have paid the purchase price and you have the evidence of payment and you're already in possession of that land, you can proceed by a vesting order and the court will order the registrar to give you a certificate of title. So here you don't have to sign the transfer forms. I hope you understand that, because that can be an oral question. So drafting, dealing in land owned by minors, that one is clear and straightforward. When you read the case of in application for legal guardianship by Wandera Peter, the court is very clear and straightforward and states that you must apply for a guardianship order and you must prove that that transaction is in the best interest of the child, subject to section 3 of the Children's Act. But the only way you can do that, for example, if you want to support the education of the child. So owner citizenship and ownership of perpetual interest in land. So we talked about that section 41 of the Land Act, which basically restricts non-citizens to own land by leasehold. But also that one is guided by Article 237 sub Article 1, which basically speaks to the effect that land in Uganda is owned by citizens. So that means that if you're not a citizen of Uganda, if you're a Kenyan, for example, you can own the land or hold land by leasehold, as we can see in the decision of Vinzika Enterprises Limited versus Vinzika Farmers Limited. That's a locus classicus case. But also, if you have some time, you can read the decision of Formula Feeds and others versus KCB Bank Limited. Trusts. Well, trusts are back here. We saw trusts in commercial, but the ones in commercial were very confusing because they did not properly meet the decision in Knight versus Knight, where they say that for you to create a valid trust, there must be 3 certainties. 1, certainty of intention. 2, certainty of objects, and also certainty of beneficiaries. But here in land, we are going to see a trust which is clear and straightforward. But in commercial land, if I can take you back, for you just scram that if you have a company limited by shares, you go and draw a trust to do a charitable organization. But you have a company limited by guarantee, you just go for an NGO. So facts, the factual scenarios in workshop 1 apply to workshop Mutati Mtandis. Mutati Mtandis. So basically Mutati Mtandis is a Latin word that means the way they are. So however, Mr. Smith's father informs you that Patience has other 2 pieces of land that she does not want to sell. He informs you that Patience informed him that she inherited a piece of land measuring 200 acres located in Hoima City from her dear mother. The late Brown Kugonza. Smith also informs you that the late Brown Kugonza had also inherited the same land from the father. This piece of land has run in the family for generations and will continue to do so in a registered, and Patience wants to obtain a certificate of title for it as the value of the land in Hoima City is steadily appreciating. Task A. Advise him on the steps you are likely to take for you to accept the instruction. So basically here, the advise him on the steps you are likely to take should you accept the introduction. So basically here they want you to transform customary land into freehold, and basically that step is clear and straightforward since it's governed by the Land Act, because you have to apply to the area land committee, you get a certificate of customer ownership, they do meetings, they do surveys, you go to the district land board, up to when you can go to the registrar and you get a certificate of title. So it's basically the process of how do you convert customer land to freehold. So the requisite documents here, we shall be looking at application form to the land board and the survey report, and also a deed plan, and also have to conduct meetings. You have to also conduct various meetings. So part B, Mr. Smith also informs you that the other piece of land is located in Leasehold Register Volume Number CD84, 45, plot number 15, Chisoro Trading Center, South Sigezi. She informs him, Mr. Smith, that that should he pass on before her children have completed university, her wish would be to have the land registered in her brother's name, Mr. Ben Atongere, for the sole purpose of holding it on behalf until when they have completed university in the USM. So basically, you look at here, they are giving you all the elements of a valid trust. There is clear intention, there are clear beneficiaries, and there's a clear object, which is the land, and it's specified. So basically, he advised him on the steps you are going to take. Basically, you have to execute a trust and also proceed to register this trust under section 54 of the RTA. So the looks like the document here would be a trust deed. So yeah, I think you see here there is no confusion like the one you had in the commercial. This one is clear and straightforward, and also matches all the essentials which were laid down in the case of need versus need, which basically speaks about the valid essentials for you to have a valid trust. So Honorable Lady Justice Ananta Mirembe has just retired from the judiciary and has received her retirement package. She's interested in purchasing all Patience's aforementioned properties in Workshop 1. She's specifically interested in the first acquiring 2 properties, namely RRV, Kasanga, Kampala, and Workshop Block 2, Busuku. She has instructed the law firm to handle the transaction on her behalf. And Mr. Smith has put on your possession and attached photocopies of the documents of title and the respective parcels of the land. Having established that the transaction in respect of the land comprised in Workshop Block is viable, and the parties have agreed on a purchase price of 20 million for the said land to be paid in 3 equal monthly installments. Task A, draft the most appropriate documents by which the sale and purchase transaction will be concluded. That's very simple and straightforward. It's a sales agreement. Advise the parties, senior partner, on the steps that you would take to cause the client to obtain the legal interest in the land. And then here you have to proceed and draft the transfer forms, you register it, you pay the stamp duty, and then you have the land transferred. And basically here, what we have before us is draft the most pertinent document is the transfer form. So the transfer form. So all the duties, levies, and fees that will be required to be paid in the process of B1 above. So first and foremost, we have the stamp duty, which is always 1% of the land. We have registration fees, which is 10,000, but also the advocate's remuneration and costs. When you look at the schedule, they have the amount of money should charge as an advocate when you're dealing with land of specific value. So you have to go back and then calculate how much money you are going to do what you are going to charge your client. But of course, most lawyers don't do this. They just bargain, and because they just bargain, and what you pay them, agreed to pay is what they take, even if you give them 20%. So the pertinent ISCO issues, then that one addresses that. If you have overcharged your client in C above, then you are here in ISCO issues. You are overcharging your client, and also you have to also do the proper due diligence. Then D, assuming that the parties have roughly entered into the transaction in C above, and after paying the first installment, the purchaser has failed to pay the balance of the purchase price, despite the several reminders. So task D, advise the vendor on the remedy or remedies you would pursue on her on her behalf, and on the procedure of invoking remedies. So basically, when you look at task D, we are dealing with a situation. Whereby task D, assuming that the parties have roughly entered into the transaction in C above, and after paying the first installment, the purchaser has failed to pay the balance of the purchase price, despite the several reminders. Advise the vendor on the remedy or you would pursue on her behalf, and on the procedure of invoking the remedies. So basically here, the vendor, the seller, you only sue for the balance. And when you look at that case of course, Katereko versus Katwiremo, but also the Veranda's case, they are saying that if you have entered the transaction and I have failed to pay the balance, then you can only do what? You can only claim for the balance, but also only. So draft the most pertinent document. So basically, the draft the most pertinent document, you have to issue the demand notice, but also proceed to draft. A plaint, because a plaint is the one which is going to help you to get the remedy. So part E, assuming on the other hand the Honorable Justice Anita purchased the land, complies in Allah, the parties in the said transaction agreed on a purchase price of 200 payable in the equal installments. She promptly paid in the first and second installments, but got wind the patients is looking for other buyers for the same land, in the belief that she grossly undersold the same and can get better price and make a refund to Honorable Justice. Advise Honorable Justice may on her rights and steps that she may take to protect their interest. So basically here, when you have bought land, the buyer can only, the buyer is only entitled to possession of the land, but also the seller is entitled to sue for balance. So you, a seller, you cannot get a new buyer and resell the land. You will have breached that contract. So you are only entitled for specific performance, which would be in this case to get the balance. And also draft the most pertinent document. So here this person would have to lodge a caveat on this land. You will have to lodge a caveat on that land, and which must also be registered under section 54. So assuming that Honorable Justice, having paid off the entire purchase price in the transaction, patient suddenly passed on without signing any transfers in her favor, though she had put the honorable possession of the land. Patient's husband is in possession of the duplicate certificate of the title and is willing to give it to her. So basically here, I advise the purchaser steps you could take to obtain the legal interest in the land. So we discussed vesting order. So basically here you proceed under section 78 and you apply for vesting order. The form for that is in schedule 7 of the RTA, and it's basically supported by a statutory declaration. And basically we say the vesting order is where you have paid the purchase price and you have the receipts for payment, and also you are in possession and you cannot get the owner to make the transfer. So the necessary documents I've talked about them: vesting order and statutory declaration. So part D, assuming on the other hand that having purchased fully paid for and got registered the proprietor, Kasanga Kampala Honorable Justice Anita Mirembe has now been contracted by CIS International Court of Arbitration as court member and has to leave for Paris immediately. However, she wants to sell off the land at a profit, and from the proceeds she intends to purchase the land comprised in Ntinda, Kampala. She is due to leave the country next week for a continuous period of 4 years, but would want the transaction to proceed even in her absence. Furnish the advice and of the most pertinent document that you would need and use to handle the transaction in his absence. So basically here we're going to be guided by section 130 of the RTA, which basically gives you the power of attorney, and it must be attested and also registered under section 54 of the RTA. So here the draft, the most appropriate document would be the powers of attorney. So H, patients having passed on one of the elder children, Bosco is opposed to the sale of any of her properties for fear that his father may use the proceeds to marry another woman. Bosco has come to you seeking that you protect his interest, if any, and those of his siblings. So since here he passed on, the steps you have to take is to apply for letters of administration. We all know that you cannot deal with property of the deceased when you don't have the letters of administration. So you have to convene a family meeting and do all the things and apply for letters of administration. So draft the requisite documents. So advise him on the steps you are likely to take. You accept the instructions. Of course, we have said that here we are going to do what? To apply for letters of administration, and the requisite documents would be it's always, I think, a petition which helps you to get what? The letters of administration. Because part 1 is saying advise him on the steps you are likely to take should you accept the instructions. Since you have already passed on, we are going to do that, but also draft the requisite documents. So you can lodge a beneficiary caveat. First one is to lodge a beneficiary caveat, and then you proceed to draft the the petition for letters of administration. But basically in land law, they might not be interested in these petitions. They might want only a caveat. So I think that's it for workshop 2. Please, if you want more discussions with me, or if you want to get summarized notes, we run a mastermind groups where members pay a monthly subscription fee of 100,000 per month to help you, to help us in all our research and get the necessary acts and all the regulations. So if you really appreciated this video, I believe that you can benefit from the mastermind. And I want to quote you this quote from Warren Buffett, that the best investment you can ever make is in yourself. The best investment you can ever make is in yourself. So please do everything you can in your possession, or in your reach, or in your budget, to make sure that you pass this bar course at once, and after that you are going to reap the fruits of your investments, of your sweat. So I hope you have a very blessed week. Please subscribe, like, comment, and share, and also turn on the notification button, so as you can always get all the updates of the new videos on every Friday, because every Friday I upload a video which derives into the analysis of the workshop and what you expected to do, so as they can help you in your revision and research as you are filling in the details. So I also want to remind you that discipline is more important than motivation. Please be disciplined for these 9 months and above, and absolutely you're going to pass the bar course. So I want to tell you that I wish you success from the bottom of my heart. And I was not also perfect, but I passed the bar course, and I believe that if you can follow all these YouTube videos, attend workshops, discussions, concentrate, or also concentrate in workshops, then there is no doubt that we are going to meet in the courtrooms. Please take care, and God will loves you, and stay blessed.